Motion carries. Scott Reeks, City Attorney, Greenfield.
I'm here, and again, I know I was not at the council meeting. I know all 5 members are here, that I was directed to come to the Charter Commission. And I think more than anything to provide help that can be provided if necessary, answer questions. We've already had a few. I do have 3 cities that I represent that have charters. There are many beneficial things. There are many things that people would find not beneficial about charters. And each of the charters I have are very different from how they were drafted, and that's what is allowed to be done with a charter, obviously. As you all know, you're on a charter commission. The majority of cities in the state do not have a charter. They are statutory cities. The league's model is a very straightforward, basic document and a good structure, but there are a lot of questions you need to look at and decide what you want to deal with on that. Actually, it was written by the namesake of my firm, Dave Kennedy, back in the 1960s, one of the first drafts that came out. And you know, he has drafted a number of charters in the state, and he's not with us anymore, but it's still a very good source because a lot of his stuff is still in print that he's put together at the league and elsewhere. You know, there are some unique things you can put in the charter. The reality is some of the things you put in a charter that you see in almost every one of them are just purely not operational. Term limits. People always talk about should you put that in a charter or not. It's not allowed in Minnesota. It doesn't matter if you put it in there, it's not going to happen. The Supreme Court has said that doesn't work. Recall situations, basically the same thing. The Supreme Court has set the standard so high under our state constitution that it's not applicable. Most charters have those. Both those, well, most charters have recall. Many had term limits. A lot of those charters have been amended to take that out that were adopted back in the 1980s.
Excuse me, can you clarify for me? Recall is not applicable, and we could put it in, but we couldn't use it?
The reality is the standard is so incredibly high that I'm not aware of a situation I've dealt with that's actually happened.
Well, that's not the way this whole thing has been explained to me.
Okay. Wow. I'm just throwing that out. You know, what my dealings with it in the cases that are out there and the points that I've seen where commissions that I've dealt with have talked about that. Most charters do have the initiative, referendum, and recall all in there.
But it sounds like it's boilerplate. I mean, if you can't have...
Yeah, most of these charters do have a very boilerplate type provision.
Which one?
Are you familiar with St. Francis and what happened there?
Yeah, that was very unique, and I haven't found an attorney that can figure out what was going on up there and how it was following what's out there as case law, in all honesty.
Did that ever get to court, or how was it decided, you know?
Well, no, I don't have all the facts off that, but I mean, seeing what was in the media and the discussion that was going on around it, that was rather unique, and there were some allegations that that I've heard that were made that maybe get you to that standard. But the standard really is, I mean, you've got somebody conducting criminal activity, very heinous type situation. The reality is, wherever you see recall being brought up in a community that has a charter, it's because of, when you boil it down, it's a political issue, and that's not going to fly. So if it's used for politics, it's not going to happen. If somebody commits murder, they're not going to be eligible for office anyways. They're going to be gone. The recall is not going to get. It's not going to come about. That's why I'm saying it doesn't get usually to that standard that the courts or the Constitution says has to be there. Which is much the same with term limits. The Constitution says if you're eligible, that's the way it is. The Constitution is not setting any type of term limit as well. And many times you see that coming up for discussion. It's not allowed. Sure, you can put recall in there. Yes, there may be the very unique situation where it gets to that level, but it is a very, very high standard. Very high standard.
Can you frame a charter and make that standard lower, or is the state statute?
I just don't think, based on what case law is out there, I mean, it is from what the Supreme Court has interpreted language, where it's been viewed, it's been a case where, yes, you have to commit such a heinous crime to get to that level. The run-of-the-mill, we don't like so-and-so because they're voting this way or they're making these determinations, which are usually the arguments you see in the cases, not going to get there. And again, most of the time that you get to that standard, it's going to take care of itself anyways because of the other operation of law and somebody's not eligible for office, et cetera, et cetera.
That is good information. I'll the public gets that one, because that's not what they have been getting.
Okay.